Okay, great. So welcome indeed to our last panel. We will be talking about artificial intelligence, a theme that has come up multiple times during the course of the day. And we will be taking a more distinctly legal angle. You've got a bunch of lawyers and legal academics before you, though I'm sure the questions and policy issues that arose earlier will certainly be germane. So I do hope to leave a good amount of time at the end for those questions. Because we are the last panel, I want to make sure that we get a chance to thank the UK government, the Association of Marshall Scholars, especially Nell Breyer. Nell, stand up for a moment, our executive director, and the Clark Center for their sponsorship of this truly wonderful day. I mean, so fascinating, such a terrific set of topics and conversations, and I, for one, have certainly learned a lot. Okay, so without further ado, I met some of you last night. I'm Jennifer No. I am a professor here at the University of Chicago Law School, where I teach administrative law and related topics. I am joined by Andy Schapiro, who I have known for years since we both clerked for Richard Posner. He is a partner at Quinn, Emanuel, Urquhart, and Sullivan. He is a star appellate advocate, and he has worked on a number of cases that involve many of the topics that he'll be speaking about. And the general topic today. And interestingly, he was also an ambassador to the Czech Republic during the Obama administration.
Lucky me.
Yes, sure, fascinating. I'm also joined by my colleagues, David Strauss, constitutional law scholar. He directs our Supreme Court and appellate clinic here. Vast range of experience, and he will be talking about the First Amendment, AI, among other issues. I should have mentioned that Andy will be talking to us about copyright issues, which came up today amongst other related issues. And then also my colleague Aziz Huck, a prolific scholar. Most recently, he's written about democratic backsliding. I think his most recent book is on the rule of law, a short introduction, which is I hope going to be widely read by many, in this room and elsewhere. And he has been involved in many of the public debates on AI. He will be talking about indeed the rule of law and some human rights related issues. So I think our panel is going to be structured a little slightly differently than some of the others. What I'll do is I'll just pick up on a theme that Louise and Bill raised earlier today about the role of government and business partnerships. So I'll just set the stage and just say a word or two about some recent efforts that the UK government has made and the US government sort of in this space, and then just offer a reflection. In my own time in government, I was recently in the Biden administration at something called the Office of Information and Regulatory Affairs, which is part of Peter Orszag's old OMB. And we basically are the White House's coordinating entity for executive branch regulations. And in that space, seeing very much firsthand the effects of AI on the regulatory process. And then I will turn it over to each of my panelists here and my colleagues to speak for a while about each of their respective topics. Depending on where we are in time, I might ask a question or two, but really I want to then turn it back all over to you. Okay, so just in terms of kind of some recent efforts of the government, and governments abroad, the UK in November of last year convened a very important AI safety summit, which was highly successful because it resulted in the signing of a joint commitment on pre-deployment testing by many countries, including the EU, the US, China, Brazil, India, and Indonesia, as well as OpenAI, Google. Now, of course, as we know, high-level commitments can mean nothing until they're actually implemented, but certainly, that is an important first step. And I think sort of generated by that energy, and certainly preceding it as well, the Biden administration in October of last year issued an executive order on safe, secure, and trustworthy development and use of AI. And there are a number of efforts ongoing as part of that EO, but just a few highlights. The EO requires AI developers to send safety test results under the Defense Production Act to the government. It charged the National Institute of Standards and Technology, NIST, with developing AI systems, security and trustworthy, and just basically guidance for this area, along with the Department of Commerce. And I think very importantly, it also really has had a number of measures focused on a hiring surge for those with AI expertise to enter government, because the government very much needs that expertise and capacity to deal with the changes that AI is bringing to government decision making. And on that note, I'll just offer a reflection or two on that front. I think what is radically going to be changing the regulatory process is the ease with which the public can use ChatGPT to write public comments that influence regulations. So for those of you that are not as close to my world, essentially, regulations, before they're finalized, go through something called a notice and comment process. Basically, when the Department of Labor wants to, classify workers and have factors for whether they're independent contractors or not, they have to provide notice to the public about their policy. And then they generally have to provide about 60 days for the public to then comment on the proposal. And then very importantly, by law, the agency then has to consider and publicly respond to each, well, not each and every, but every material comment is one of the legal kind of doctrinal hooks. And, of course, conservative agencies are going to try to, conservative in the sense of litigation, conservative, are going to want to respond to as many as possible. So as you can imagine, as some of you know, the FCC net neutrality rulemaking, this was even before ChatGPT, generated something like 23 million comments. And interestingly, a very small percentage of them, I want to say 6%, were unique comments, meaning that the rest of them were just mass generated duplicative comments that have to be poured over by these agencies before they can respond. So I saw this from the inside. It is a huge resource drain for the agencies to have to sift through all of these comments and then respond to them. And the only way I think that going forward that the government is going to be able to effectively respond is to fight AI with AI. So they are now deploying forms of their own AI to deduplicate, to sift through, summarize the comments. And then there are some really thorny legal questions that result from that, and that are just now going to be raising new legal questions in the courts. For example, given the fact that many of the agencies don't have the capacity to read these themselves, they contract with private companies who are then doing the sifting and the reading and the sorting of the comments. And so is it okay for an agency simply to read those summaries, not to actually look at the comments? Does that fulfill their legal requirement to actually consider and formulate the policy with respect to those comments? And so anyway, this is just to give a flavor of some of the issues that I was seeing very much in real time as I left in February of this year, of the kinds of challenges facing the government as it grapples with the new forms of AI. So anyway, more on that to be potentially talked about during Q&A. Let me turn it over to Andy now to talk about copyright and some of his experiences.
So I am assuming that this is an audience mainly of non-lawyers, although lawyers are mixed in, but certainly the people I've been sitting next to at the various events during the last couple of days have been from all areas. So I'm going to do something that law professors sometimes just call issue spotting. I think that might be a little more interesting for generalists than getting too deep into the weeds. But first, I think just a little context. Oh, and one other thing, because this is being recorded, I guess, and I do some work for OpenAI and NVIDIA and Google, Google, and this is all just my own opinion. This has nothing to do with any cases that I have or clients that I have. So it's not at all uncommon when you have a new technology upending the way we do anything, really, to have a freak out in the copyright world. And the law tends to follow behind. I mean, I think probably in most areas law follows behind developments, but that's particularly so in copyright. So when the player piano came out in the in the 19th century or early 20th century, the sheet music folks who had only recently gotten copyright protection started freaking out. This is going to kill creativity. No one will compose music anymore because the way we make money is selling our sheet music so that people can play it at home. Congress amended the copyright law, gave some protection to mechanical reproduction. Later on, when I was a Marshall Scholar in England in the 1980s, I remember there was a big campaign, maybe there was in the United States too, home taping is killing music. I was like, you know what, now because you have cassette tapes out there, no one is going to create music anymore. But eventually the industry adapted. The content owners tried to sue the Sony Betamax out of existence. That went up to the US Supreme Court, that case, about whether whether the Betamax itself or Sony could be held liable because people were using VCRs to tape shows. And I've seen the same thing just with regard to streaming. Now, the content companies were freaking out for a long time, saying, oh my God, the fact that there are these digital copies out in the wild, we can't sell you a CD for $15 now where you have to buy 11 songs and just to get the one that you want. But the industry tends to adjust. I think that's going to be happening with AI right now. We're in the freak out phase. So I printed out a list of them that we keep going in our firm. There are 18 or 20 major cases pending in district courts right now of various flavors that are going to make the law for the foreseeable future. And then eventually, my guess is whether it's Congress or just through common law, it's going to set the stage for how we think about AI. Almost all of those cases are either in the Northern District of California, which is San Francisco, San Jose, usually because of the terms of service of some of these companies, Southern District of New York for various business reasons, a few are in Delaware. And in almost none of them have there been any important substantive rulings yet. There are about 13 different cases where motions to dismiss are pending. Those are going to create some law relatively soon. So we're in a really interesting area for lawyers over the next few years. You're sort of making the law. And when I describe the freak out, there's two extremes. So on one hand, the people who are representing the tech platforms or the scrapers or the AI companies, mainly what I do, those are the companies that we represent, will take what I would say probably a maximalist position and interpreting something that's called the fair use doctrine, which more or less says you're not infringing copyright if you're using the material for a transformative purpose, and if you're not using too much of it. It's deeper than that, but that's essentially it. So the people on that side, the information wants to be free side, are saying, hey, Sarah Silverman and other authors, what are you doing suing OpenAI? Because all that OpenAI did is I could sit at home and read every book and monologue that Sarah Silverman, she's a comedian, she's the named plaintiff in one of these cases. I could read every book or monologue by Sarah Silverman to try to learn myself how to be funny like Sarah Silverman. That's plainly a fair use. So why is it any different if I train OpenAI by feeding it all this Sarah Silverman stuff and ask it to give me some output that's like Sarah Silverman? At the other end of the spectrum, also a maximalist position, and is what I sometimes call the content cartel. We're saying anything you do that touches on our works, we should be paid for. You can't train on our works. You can't take snippets of our works. And they tend to divide their complaints into two different tracks, input and output, right? Is it a copyright violation to use all of my books or my songs without paying me a license to train the AI? That's the input side. Or the output side, which came up in a case that got a fair amount of publicity when it was filed by the New York Times against OpenAI, saying, well, wait a minute, I'm putting in some prompts into ChatGPT, and it's reproducing almost verbatim some New York Times articles. So those are the positions that are out there. I have my views about what's right. In the meantime, businesses want to plow ahead. And so in some of these instances, I think these issues are going to be resolved, at least in the near term, simply by the businesses and the content owners agreeing to lay down their swords and agree to licensing deals without agreeing that there's an actual need to do it. So OpenAI reached licensing deals with Axel Springer. It's a big publishing concern around the world to say, you're going to agree that we can scrape your stuff. We're not saying that you have the right to fence us out, but just so that we can be busy making money instead of litigating. They did the same thing with Reddit. So when we can deal with Reddit, we can scrape your site. We'll share some of the profits with you. We're not saying we have to do it. I think we're in an interesting time in that regard. I think the fair use arguments for input are very, very strong. One final thing, I don't want to take up too much time. I could go on forever about this. We'll let you get to other people. But some of these cases are going to turn on some very technical, narrow issues. So the copyright law says it applies, for example, if you make a copy of something or a derivative work, for example. In some of these cases, there are big fights going on right now in discovery about what happens in the black box that is AI. And weirdly, even the AI companies themselves don't always know. But the AI companies are saying, no, no, no. This is not like we are just sucking in all the content of the New York Times, making a copy of it and searching it. We just kind of run it through. We tokenize each word. We make some, there's some network inside the AI that decides if you see the word cat, it's more likely to be near the word brown than it is near the word green, blah, 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 blah. We're not making a copy of anything. But behind the scenes there, what if there's an ephemeral copy, which there may be, just like very briefly, it's like sucking it in, getting rid of it. And some of these cases may be won or lost on something as simple as that, as whether there's an actual copy made in the process. I'll pause and we'll see if we have more time and I can rant.
So my subject is the First Amendment and artificial intelligence. And by First Amendment, there's a set of legal principles and rules associated with the First Amendment, but it also is a stand-in for a larger culture of free speech that operates even where the First Amendment itself does not. For example, in private universities and the practice of journalists, and maybe more broadly in society. I want to focus on two challenges in particular that AI poses to the First Amendment and to that system. One has to do with deep fakes, which are representations of events that did not happen, but the representations are extremely accurate. And it's very difficult for any observer, certainly any casual observer, and maybe even a sophisticated observer, to tell that those events did not happen. And the other thing I'll talk about a bit is the way AI can target speech to particular small groups or even to particular individuals. Now, the sort of freakouts that Andy was talking about in intellectual property happen on the First Amendment side too, that there's a new technology. This has been going on for at least decades. You could even make a case it's been going on for centuries, since the printing press and certainly since the availability of sort of mass pamphleting and mass circulation newspapers. And the form the freakout takes is there's a new technology, and the sort of world divides into people. Sort of it's a face-off between alarmism and complacency, where you see some people saying, "Oh, that we have to rethink everything. The sort of norms we had governing free speech, they're obsolete. They have to go." Most recently, this has been done a lot in connection with social media, where there is a sort of a subgenre of scholarship saying, "Isn't the First Amendment obsolete now?" And then the complacency side is, "Oh, what are you talking about? It's just a new sort of way of applying our old principles. Technology changes in lots of areas. We just apply our principles to the new areas." So you see that kind of a dichotomous way of thinking. I actually find that not that useful because it's on too grand a scale. But what I do think technology does is to reveal difficulties, vulnerabilities, weak points, sort of fault lines in our current ways of thinking about things. And by that, I mean principles that have come to be accepted, but they're not quite right. We've learned to live with them, even though they don't really quite work, but they do okay. And so we live with them, and they've even become foundational to our ways of thinking about free speech. And then a new technology comes along, and it reveals the problems in that way of thinking. So let me give you an abstract example and then a concrete example that brings us back to deepfakes. The abstract example is the idea that, if you don't like speech, the remedy isn't to suppress the speech. The remedy is more speech. The remedy is to speak against the speech you don't like. Don't suppress it, answer it. That's a pretty good principle. There's a lot to be said for that principle. There's some areas in which it obviously doesn't apply. It doesn't help if you're concerned about national security secrets. It doesn't help if you're concerned about invasions of privacy. They're saying, well, more speech is, more like the disease than the cure. But if you're talking about bad ideas, well, the idea, no, fight ideas with ideas seems to make sense. But it obviously has some difficulties. There are going to be instances in which more speech really does not fix the problem. But it's worked pretty well. One area in which it really has kind of taken hold, with a couple of exceptions, is the government, by and large, with some exceptions I'll mention in a second, cannot outlaw a statement just because it is a false statement of facts. There are exceptions for commercial fraud. There's an exception for defamation if it's defamation of a particular person. But, as you think about it, we don't want litigation over whether one political candidate has mischaracterized another political candidate's positions, or has misrepresented the state of the economy, or what that candidate will do if elected. We don't want litigation about all that. The answer to that is answering speech. So this principle that just because something is a false statement of fact, with certain limited exceptions, it can't be prohibited, that's sort of a foundational principle. The availability of artificial intelligence and certain other digital means of communication has really challenged that. And it's not an entirely new thing, but deep fakes, because they are so easy to propagate, because they are so difficult to detect, and because they can be done at such scale, really pose a challenge to this idea that, no, if it's false speech, answer it, expose its falsehood. It's going to be very difficult, much more difficult to do now than it has been in the past. It's not to say this is entirely new. You remember the Orson Welles, we probably remember firsthand, but I certainly don't, the Orson Welles War of the Worlds, where there was a radio broadcast in which he said we've been invaded by aliens. I think they landed near Princeton, New Jersey. I don't know why. And people took it seriously, and there was sort of a major commotion and major disruption because people thought we'd been invaded by aliens. Well, that was a deep fake. He sort of used a new medium to communicate something, and people couldn't see through it. So it's not entirely new, but as I said, it can be done with ease and effectively and at scale. Now, the Orson Welles incident actually kind of provides a hint of one way out, that this is more likely to be a problem when a means of communication is new, because people don't know quite how to detect whether it's phony. So as AI becomes more common, as something to pick up on something Jen said about you can fight AI with AI, as AI means of detecting deep fakes become useful, maybe this problem will to some extent solve itself. The same way, if there were a phony radio broadcast today, it's unlikely to have the effect of Orson Welles's. I think it is the case that when photographs first became usable as evidence in court, there were major problems about how do we know it's not faked? How do we know this actually happened? We overcame that. Maybe we can overcome the comparable problem with AI. But it has identified a fault line, which is, we think, if something is a false statement, rebut it, don't suppress it. Much tougher to rebut a deep fake. The second fault line has to do with the targeting speech on particular small groups of particular individuals. This is again an area in which the foundational First Amendment principles are not fully worked out. The law has a very difficult time dealing with face-to-face speech. The sort of paradigm for free speech is, some kind of corny Norman Rockwell-ish thing of the person standing up in front of a meeting and addressing the public on a matter of public interest. But rules developed for that often don't apply very well if it's face-to-face speech. So, for example, something that would be, you might hear denigrating comments, a racial or religious slur in a public speech, you have a First Amendment right to say that if you're speaking to the public. Said face-to-face, it could constitute harassment and be illegal because it's face-to-face. So face-to-face speech gets treated differently. What AI and to some extent digital communication generally have done is to scramble this idea of what's face-to-face. It's no longer literally face-to-face. It can be someone who's nowhere near you, but is targeting you with communications. and doesn't have to back that up with a physical presence. And that makes it much more easy to inflict the kinds of harms that can be inflicted by face-to-face speech without being face-to-face. And we really don't have a settled way of dealing with that. And that's going to become increasingly an issue. Actually, already has become an issue, sort of targeted doxing campaigns, which are the equivalent in the digital world of the kind of face-to-face speech we can prohibit. You start prohibiting in the digital world, you open up lots of questions about, well, wait a second, I mean, that's being done on a large scale. Is it really face-to-face anymore? So we need to figure out ways to deal with that. Now, as far as the way out of this, my instinct, this is sort of, again, something Jen said about maybe, at least with deepfakes, AI will provide the answer as well as presenting the problem. And the other thing is we do have these tools to deal with these things, and we do have ways of getting at commercial fraud, but not having the laws regulating commercial fraud spill over into the areas in which we really don't want to police the truth of speech, because we don't want litigation over the truth of statements about, the budget, et cetera. And similarly with face-to-face speech, we do have some ideas about what constitutes impermissible harassment, following someone down the street, screaming epithets at that person. All you're doing is walking and talking, but it's pretty clear that can be punished, even though it's speech. And whether it can be punished depends on what you're saying. If you're asking for directions, okay, that's one thing. If you're calling the person, if you're using a racial epithet, that's a different thing. If you're saying baby killer to a person entering an abortion clinic, maybe that's a different thing too. But we have ways of thinking about that, and it's possible that we can kind of figure out how to apply that to the digital world. So I don't think it's necessarily beyond our capacity to deal with these things, but they pose real challenges. And the interesting thing about the challenge is, in a sense, it's not really new. In a sense, it's been there all along. We knew these were problems. We knew we didn't have a perfect solution. And what the new world of artificial intelligence and the digital world generally does is to force us to confront the imperfections and the solutions we think we have.
Thanks, David. Turn it over to Aziz.
Thanks. So I've been asked to talk a little bit about how ideas about the rule of law apply to AI. The reason for concern about the rule of law with respect to AI is the widespread adoption of AI tools within government. A few years ago, the Administrative Conference of the United States conducted a survey of how civilian agencies use AI. They found 64 bureaus, departments, agencies within the federal government using some 157 tools. That's the civilian agencies alone. Doesn't count DHS, doesn't count military entities, doesn't count the countless police departments, municipal authorities, state government agencies that also use AI around the country. AI, moreover, is used from the very beginning, the regulatory process, up until the post-adjudicative stage. For example, federal agencies use AI tools to identify problems to regulate. The SEC, for instance, uses it to identify anomalous patterns of trading. The IRS, a little bit further down the chain, uses it to determine who to audit. And then after the government has acted, AI can be used in the adjudicative stage, for example, in sentencing proceedings with respect to determinations of threats of physical harm, and even in the post-conviction, post-sentence, post-incarceration, determinations about parole and release are increasingly relying upon predictive tools, some of which include AI. So AI is used broadly across the spectrum of governmental activities, and as such is thought to raise a concern about how power under the guise of law is implemented. The tradition of thinking we have for evaluating the use of power through law, at least one important strand of that tradition is called the rule of law tradition. But the rule of law tradition isn't unitary. It traces its roots back to a number of different early modern thinkers, Locke, Montesquieu, Hobbes. It has a what you might call a legalistic component or a legalistic heritage. It has a much more libertarian heritage in the form of figures like Hayek. If I could draw two ideas from that relatively complex intellectual history that are salient to the implementation of AI by government today. They would be a concern about guidance and a concern about constraint. One important strand of the rule of law tradition associated today with the legal thinker Joseph Raz is the idea that law is effectual if it can provide guidance, if it is stable, accessible, clear, comprehensible to those whom the law would subject to its commands. A law that does not provide guidance is one that is not capable of performing its core function, is therefore not compliant with the rule of law. The second strand of rule of law thinking views the guidance account of the rule of law as excessively formal, as excessively pinched in its normative aspirations. And it insists that if the rule of law is to be viewed as a good, an aspiration toward which law and society should aim, it has to do more. And that strand of rule of law thinking focuses upon the capacity of the law not just to empower agents of the state, but to constrain them, to impose limits on their conduct that make their actions predictable and legitimate in the eyes of the people who the law subjects. So there's a constraint and there's a guidance function of the rule of law. One of the reasons I think that AI presents an interesting case study for the rule of law is its effects upon the guidance function and the constraint function of the rule of law cut in opposite directions. I think it's plausible to say that AI will make the guidance function of the law easier to execute, and it will make the constraining function of the rule of law more difficult to achieve. What do I mean by that? The guidance function of the rule of law is associated with the idea of clear and stable and predictable legal rules. In an important way, the implementation or the intrication of AI into either pre or post adjudicative mechanisms, either pre-trial when the government investigates, or post-trial when it's determining what sentence or punishment is going to be imposed. Substituting AI for human judgment leads to more stable, regular, and predictable outcomes. Why? It takes out of the picture one of the most stochastic elements of the legal process, the individual judgment that's associated with line decision makers, from probation officers to judges to the person who hands you your license or doesn't hand you your license at the DMV. So in an important way, AI is a source of stability. I think there is a counter argument to that with respect to the guidance function. It's the idea that even if AI is predictable, it's more opaque and therefore is perceived as less predictable. The European Union, I think, acting on that impulse, has included in the GDPR something that might be called a right to a human decision. You're entitled under certain conditions to object to the fact that you've been subject to an automated decision and say, I have a right to appeal to a human decision maker. And I think the intuition there is that the human decision maker is somehow less opaque and therefore more predictable. I think that argument is based upon a fallacy. Human decision-making, as I think a moment's reflection about anyone's own experience reflects, is just as unpredictable and can be as opaque as a machine. And there are ways, increasingly in the technical literature on AI, of supplementing AI decision-making tools with explanations that render those tools reasonably transparent to ordinary, non-technically trained individuals. So all in all, I think that the guidance function of the rule of law is likely to be furthered rather than hindered by AI. Now, the constraining function of the rule of law, I think, is a very different story. When people think about the effect of AI on state power, I think that the paradigmatic example that they go to is China, where the weaving in of facial recognition, gait recognition, GAIT recognition, and ethnic identity recognition tools into the extensive system of public surveillance cameras that cover most Chinese cities means that individuals have dramatically less physical freedom to move around than they used to. Their decisional freedom is constrained by the use of AI tools that are implemented through what's called a social credit system, and the quite tight controls that are implemented, again using AI, on social media and electronic communications. I would not reason from the Chinese example to the conclusion that AI presents a concern along the constraint margin of the rule of law in the United States. Recent work by a political scientist called Minchen Pai demonstrates that the surveillance state in China rests and ultimately depends on an incredibly labor-intensive network of individuals, both within the government and the party, and dispersed among society, but responsible to the party state for its functioning. In the absence of the right kind of governmental infrastructure, that is, the kind of surveillance state that you have in China is unlikely to emerge in Western democracies like the United States or the UK. What I do think is more likely to emerge, or what I do think presents a real threat, is the possibility that public-private partnerships using AI will develop in ways that allow at least certain parts of the state to escape the reasonable control of its citizenry. A distinctive feature of AI is that it is a technology of scale. You need a lot of data, you need a lot of compute in order to instrumentalize, to create an AI and to use an AI instrument effectively in the world. Because it is a technology of scale, AI is an instrument that benefits organizations, entities that exist at scale, rather than dispersed individuals. In Western democracies, the state is one of those organizations, entities that exist at scale, but so are private entities. And the state and private entities often act in ways that are in harmony. The state often depends upon private entities for the provision of services, and the public sector, the private sector, excuse me, often anticipates the demands or the interests of the state. To the extent that that one ought to be concerned about the effect of AI on the constraining function of law on the state, where I would focus is on the possibility of public-private partnerships whereby private firms develop instruments of surveillance and coercion that can then be sold to the government and instrumentalized in ways that are profoundly harmful to or profoundly damaging to the ability of the citizenry to keep the people they elect under check.
Great. So we've just heard about some disparate topics. And I think one unifying question that is in this space is what exactly is the difference between sort of artificialness or intelligence and something that is sort of fundamentally human? And Aziz, you've touched on this question, but I wonder if we could just draw it out across some of these areas a little bit more. So for example, I can say in my own space, there is an argument that if ChatGPT makes these, points and draws together studies against some proposed rulemaking, that it's somehow less valid because an individual hasn't made them themselves, and they're just trying to generate, either try to gunk up the system or just trying to oppose a rule. And so the House recently passed a bill, for example, requiring agencies to use CAPTCHA and like other techniques in order to ensure that it's a human actually submitting the comment. In the copyright space, my understanding is that there is an argument that copyright should not protect the kind of art that is generated by those using ChatGPT and these other forms of AI to feed in a lot of images and create their new art. My understanding there's an argument that copyright should only protect human generated art. And then in the free speech, First Amendment space, there's this perennial debate: is First Amendment protect the speaker, the human speaker, or just speech? And it's just the information itself that's important, rather than the fact that it's generated by a human. And of course, Aziz, you've already talked a bit about the so-called right to a human decision maker. So I guess the question is what do you see as, yourselves in all the experiences that you've had, in terms of like, what is the fundamental human thing that is lost through AI? Is it empathy? Is it creativity? Something else? And then should the law protect it?
Well, you're right that for now at least, the Copyright Office has said that if something you generate a poem or something like that, and you're just using AI, that's not copyrightable. You have to show that there was some contribution of originality from you. And copyright is in the Constitution, right? It's to copyright to protect, to promote the useful arts and sciences. I don't know, you guys are the con law professors, but the idea was originally, well, if you don't have copyright, you're not going to have humans doing these things that make our lives better. It feels a little bit different. If you said to me, it would make me sad, but I can't tell you why. It would make me sad if you told me, we don't need, pop musicians anymore or classical composers, because AI can do all those things for us. I don't think, here I'm not talking as a lawyer at all. I'm just talking as someone who's, a human who's thinking about these things. I hope that it's still going to matter to us, because it's much more interesting to see Steph Curry hit, 5 3-pointers in a row than it would be to see a machine hit. No one would pay to see a machine hit 5 3-pointers in a row. So I think it will still be more interesting to listen to a song that was written, to pay money for a song, or to pay money to go to a concert by a human doing something, because we're identifying with that. We're saying, look at what a human can do. That's impressive. I'm so impressed with how, Mick Jagger at age 80 is still going to be at Soldier Field next weekend, or whatever it is, or these great songs, in a way that wouldn't move us if a machine did it. But if it turns out that there can be no that machines can generate songs that are as good or as interesting and catchy as a Taylor Swift song, and you don't know who generated it, and it's not copyrighted, so it can just be out there without any license or anything, we've really may be at a point where the incentive for individuals to create is sufficiently reduced that it starts to stem the amount of original work that we get.
What Annie just said this is not really my First Amendment subject, but reminded me of something that Louis Menand, a professor at Harvard, said in a review of, about the Olympics. I think he was writing about the Olympics. And he said, why are we, it was a rhetorical question, why are we so fascinated with gymnastics when the best gymnasts in the world are markedly inferior to just the average squirrel in your backyard, jumping from limb to limb? So yeah, seeing people do stuff is impressive, even though, not machines, but also animals can do a lot of this stuff a lot better. But, somehow we're some sort of species-focused narcissism. We think, boy, that's great that a human can do it. But to Jen's question about artificial intelligence and speech, and is AI-generated product speech, sort of two things align with kind of what I said before. One is that it sort of forces us to focus on something about the way we think about speech that we otherwise might elide. And the other is to ask that question, even, which gets asked a lot, is misdirection. So here's what I mean by that. You could set up a machine that would produce random human-like noises and words. Now, would that machine, if I set up that machine and the government comes along and takes it down, does that violate the First Amendment? That really seems implausible. But having said that, there is something about, people speaking and speaking their minds, and we want to value that. And that's part of the system of free expression. So that's one thing. The reason I think it's misdirection is that a lot of times these questions, is this speech, does the First Amendment protect this? It's a non-answerable question because you've left out too much of the context, and the context is why does the government care? So when someone burns a flag, is that protected by the First Amendment? I can't answer that question until you tell me why the government cares that he's burning the flag. Does the government care he's burning the flag because the government thinks it's disrespectful to the flag or to the United States government? Well, then there's a First Amendment issue, and maybe he can do it, maybe he can't, but that's a First Amendment issue. Does the government care about burning the flag because he's doing it in the forest during a dry season? Well, no, there's no First Amendment issue there. You can't answer that question without looking at why the government cares. So if the government wants to restrict the output of artificial intelligence entities, you have to ask, well, why do they care? Why do they care about what's coming out? Before you can answer whether there's a First Amendment problem. If they care because they're worried about the content of the speech in some way, well, okay, then we have to ask First Amendment questions. If they care about for other reasons, copyright has this very kind of weird position in the First Amendment law where lots of things that are allowed to protect copyright seem unacceptable in other areas, but clearly acceptable for copyright. So that would present some issues. If it has nothing to do with the content of speech or the issues that we care about when we're designing a system of protection, then there's simply no First Amendment issue. But I think sort of the question itself, as I said, kind of forces us to think, to what extent are we concerned about people being well informed, people gathering information, and to what extent are we concerned about acts of conscience? Both are in play, but to what extent we value one or the other if they come in conflict with important government interests. And then to the extent we care about what listeners are receiving, what people are receiving, then I think you have to say, well, stop focusing on the speech, the speech or what was claimed to be speech, and start thinking about why do we care? Why do we care about it? And that is often the decisive question. So once again, that kind of these changes are tough to deal with, but also kind of illuminating and maybe produce progress in the way we think about the overall system of free expression.
I heard in Jen's question a descriptive and a question of value. On the descriptive question, I don't think that there is a clean way of dividing between machine and human decisions. I think the most recent wave of generative text tools illustrates that. Most of these tools are, in effect, two different procedures bolted onto each other. One is something called a transformer model, which is essentially a very complex neural network. And the second is a process of reinforcement learning through human feedback, where you have a bunch of human testers who rate responses to the outputs of the initial transformer model. And it turns out to be impossible to create an effectual generative, or very difficult at least so far, to create an effective generative text tool without having that last stage of human feedback. Almost every tool, like ChatGPT, is woven together through some complex blend of human and human design decisions, human choice, and machine action. And it seems to me not worthwhile trying to figure out how to pull those apart. On the question of value, I think I agree with Andy and David that the Anglo-American legal tradition, at least, has always accepted the basic liberal predicate that the measure of value, the basic humanist predicate, that the source or unit of value is the human being. And to the extent that things that are not human, be they jumping squirrels, beautiful sunrises, etc., matter, they matter if and only if they matter to human beings. So humans are the measure of value. But I think I disagree with Andy with respect to the possibility that humans can value things that are themselves not humanly produced. So the beautiful sunset, the view that you have from a mountain are not, by most accounts, humanly produced. They may be humanly inflected because of pollution, but they are, in some fashion, appreciated as non-human phenomena. I don't see any reason why that cannot be the case with respect to the products of AI. I think this is probably true for many of the cases of deepfakes that David mentioned. I'll give a different example. In Japan, because of the demographic crisis that Japan is experiencing with the declining birth rate and the absence of a labor force that can serve their graying population. One of the tools that's come into actually quite widespread and successful use to mitigate some of the psychological harms of loneliness in old age is the use of robots as companions for older people. And at least up until now, the empirical record of robot companions for the elderly in places where they are widely adopted, such as Japan, is extremely positive. People absolutely understand that their companions are not people. They absolutely understand that they are programmed, and yet they have enormous emotional investments with clear welfare payoffs from those human-machine interactions. So it strikes me as being utterly plausible to say that you can have a legal world which recognizes that value flows from people and people alone, and yet also say, well, there are some things out there that are the products or instantiations of just machine action that are themselves valuable, not because they're human created, but because there's some human being that cares deeply about them.
All right, well, I know many in this audience have been thinking about these themes, so I want to open it up for questions. And I think we have some folks with mics going around. Should we start with Bill up here?
Very short question. I may have missed it, but I didn't hear any of you discuss how to think about, in these various contexts, the phenomenon of hallucinations.
I can't talk about that with regard to, I don't have an opinion about that with regard to copyright, but I can tell you as a practicing lawyer, and you've probably read all these stories yourself, a bunch of lawyers have gotten into trouble for writing briefs that look entirely plausible, and they will cite a case, Smith versus Jones held blah, 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 7th Circuit, 1993. And so I saw some foolish lawyer asked the generative AI, is this a real site? And I said, yes, it is. And he's like, well, that's okay. And judges have come down hard on those. That's probably all I've got about hallucinations, other than some existential dread that we will soon be in a world where we just have no idea what's true and what's real at all. And that's coming, but maybe after my lifetime.
I mean, hallucinations produced by AI, that's sort of the ChatGPT spits out something that's not true. Yeah, part of what's going on there, I think, is the deception. That if someone were to say, look, I got these from ChatGPT, we all know ChatGPT is capable of hallucinations, so treat it accordingly. It would be a different feel. Lots of times we come across historical records, and we're not sure whether what's in the historical record is reliable or not. And you can kind of say, well, here it is. This is the best I can do. I think it shows that these things happened, but not sure. And you could see this becoming like that as long as we know what we're dealing with, we can manage it. The real problem comes when someone presents it as something that was the product of a system that is very unlikely to produce fake sites, like a person in a library, presents it as something that is in fact capable of producing unreliable information. But I think that I would locate it more as the deceptiveness of what the lawyer did rather than something about AI in particular.
I take hallucinations to be a new version of an old problem, which is that a technology comes along. People think that the technology is going to revolutionize the world, but when the technology is rolled out, it turns out that there are these gaps between the world and the technology. And the hallucination problem is, I think, an unexpected effect of, or an unexpected output of almost all generative AI models that demonstrates a kind of or creates a difficulty with implementation in the world. And probably its most important short-term feature is that it's dramatically slowing commercial adoptions of AI. I think it is less important than what I think is underlying the problem of hallucinations, which is this, that when you craft a generative AI tool, as I understand it, you particularly at the human reinforcement or the reinforcement learning through human feedback stage, you have to make a set of judgments about how the empirical world that's being reported on or that's being reflected, perhaps that's a better verb, by the AI fits together, how it coheres and how it therefore is depicted. And as anyone who's written a legal brief or a term report or story knows, there are many, many different ways of cohering, of putting together even relatively simple fact patterns. And it turns out that there are structural choices that are built into generative AI with respect to how you deal with the coherence problem. Because there are different ways of dealing with the coherence problem, and because those different ways are going to have predictable political or normative valences, it is necessarily the case that generative AI tools will have what is understandable in the world as a slant. It was possible, I was going to say it was now possible. It was possible within about 2 weeks of the release of GPT-3 to write a version of a generative AI program that was the liberal generative AI. And then a couple of weeks later, there was a conservative generative AI. And then there's a Proud Boys generative AI. You just keep going down the list. And there's no such thing as a neutral generative AI. So that to me seems profoundly more difficult, profoundly more destabilizing because of the absence of a kind of neutral ground at the level of the system, at the level of the how do you cohere the world in general? What's your method for doing that? Right? That's much, much harder than is this case citation made up? We have an answer to the is the case citation made up question. We do not have an answer to what is the right way to cohere the world.
So the short follow-up is, why is a hallucinating AI different from Donald Trump?
I think that may count as a rhetorical question.
Thank you for a great conversation. To what degree do you think the actual output of AI, which is text and to some degree audiovisual, human beings see as ineffably human, and that sort of confounds and conflates this perhaps different areas of law, that you've got product liability, you've got copyright, right, and then First Amendment issues and maybe other things, that we tend to bundle them all together when it's words and pictures, but we don't when it's a grain or when it's this can or when it's my car. So to the extent you've had automation and massive productivity gains and then subsequent unemployment in agriculture and then industry, if it's coming to knowledge work, why is that not a continuum, and what is qualitatively different about this?
Might be qualitatively different because it affects us. And
Like us here?
us here, I'm in a room full of academics and martial scholars. And the thing that we might need to make our peace with is all of us, I'm betting, for most of our lives, thought, well, gosh, I'm special because I'm smart, or I'm a good writer, or whatever it is, or I can compose music. That makes me special. But in fact, sadly, we're learning those things make us no more special than someone who could lift a really heavy bale of hay was special 150 years ago and is no longer special. And we're the commentators about it. So the reason, you're saying, well, why are we reacting differently is the person who could lift a really heavy bale of hay 150 years ago and then who started to think, I guess I'm not that special anymore because a forklift can just do it. He wasn't writing articles in the New York Review of Books about it or anything, and we are. But we can still experience things. So maybe we will just end up as sponges who can experience things, and that's still okay. We can love an AI, and we can grieve, and we can experience that sunset you were talking about, which I don't think AI can. But it's unnerving, and I think it's especially unnerving for people like us, because I guarantee you, I mean, it's not just in my, in 2 or 3 years less, the work that the associates in our firms do, AI will be able to do. Here's a motion to dismiss, write a persuasive reply, check all their cases, and in 3 or 4 years, the work that I do as a partner, AI will be able to do. maybe the judges eventually, you were talking about that, we'll see. So, okay, we're not special.
I don't know if this is where you're taking the question, but it reminded me of something Aziz adverted to, which is whether there is some irreducible thing that human beings have that just cannot be captured by a machine. And a while ago, it was you could say, yeah, we can use machines or of various kinds to kind of narrow down a range of decision. But in the end, if it's a judgment call, that's got to be made by a person.
Could never beat a chess master. There was a
that was
never beat a chess master.
That was right. And whether there's anything left to that. I mean, I think the intuition that yes, there is something human beings can supply that a machine will never be able to supply. I think that intuition is widespread and appealing, but it might just be narcissism, or it could be. It could be. And at some point you sort of wonder, well, okay, if machines become increasingly sophisticated, maybe there's some residuum that humans can supply, but in the world, it's not going to matter. So there's no point in having a human decision maker at all. But I think that intuition is very strong, and I don't think there's an answer, but maybe there is, to the question whether there is some irreducible thing that only human beings can supply.
I think if you told my parents that 60% of the population would choose their romantic partner by relying on a machine, which is what a dating app is, they would have thought, that's crazy. Why would anyone outsource the most important, the most profoundly consequential decision of most people's lives, not everybody's, most people's lives, like who they will partner with romantically, to a machine? That would seem crazy. And yet it has become our reality. And it's become a reality within my lifetime. So I don't see any reason to think that there's any kind of decision that human beings, or any kind of choice that human beings make, that can't be denaturalized and reinscribed as something amenable to technological choice. And so and what counts as being something that is intrinsically human as a decision, I think is utterly, it's not just culturally contingent, but profoundly unstable, which is what, to my mind, the dating example demonstrates.
Now, how are we doing on time? Okay, we're good. All right. So please join me in thanking our panelists. We'll look forward to continuing the conversation during the reception. Thanks, guys.